All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Joe Boatwright, Judge, presiding. All persons have business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Thank you. Good morning, and welcome to the 5th District Court of Appeal oral arguments. Today, we are here in Putnam County, and thank you for having us. Let me first start by introducing the judges on our panel. I am Judge Boatwright. To my right is Judge Brian Lambert, and to my left is Judge Adrian Sow. Also, we are going to have two school groups with us this morning. We do have a group from Palatka High School here right now, and then we should have members of the mock trial team from QI Roberts. Also want to recognize here, I can see our clerk of court, Matt Reynolds, here this morning. Good morning, Mr. Reynolds. And I also believe this may be the second time that we have been in Putnam County sitting for oral arguments. And Judge Lambert, when he was chief judge last year, he set this up for us, so thank you for him for doing that. And current Chief Judge Jim Edwards scheduled us this year. This is very good for the county to be recognized in this fashion and good for our legal community. And if you could at this time, please silence all cell phones and devices. We do have 3 cases on the docket this morning. Each side will have 20 minutes to argue their case. The appellant is allowed time for rebuttal argument, so when you come forward, let us know how much time you would like for rebuttal. We also will leave time for the school groups to ask questions this morning, and depending on the timing, it may be after each case or at the end of the docket. So the first case we have this morning is case number 2022-2255, Benjamin Richard Harris versus the State of Florida. Is the appellant ready?
Yes, Your Honor.
Okay.
Good morning, Your Honors.
Good morning.
Matthews Bard on behalf of Mr. Harris. May it please the court. I am requesting 5 minutes of rebuttal time. Your Honors, we have brought forward 5 issues before this court. One is broken up into 2 subparts, that of the judgment of acquittal based on whether the legislation itself proscribed the allegations against Mr. Harris, thus an issue of statutory construction. We've also brought forth that the pyramiding of inferences was exceeded what would be allowed for a conviction of Mr. Harris as well. We also raised our objection to the state's closing argument, and that too is in 2 parts. The first part being that the Pledge of Allegiance was recited in part, and there was an improper opinion that was objected to by trial counsel, and went on to appeal to the emotions, sympathies, and sense of civic duty of the jury, thus vitiating the impartiality, a calm and dispassionate review of the evidence, making the jury feel that there was some pledge to save the republic. And then there was the issue of the state in closing argument stating that how did this information get onto the record that was produced? And the state said it must have been magic, which our position is that is shifting the burden to the defendant to explain how the information got on the sheet. There are a couple cases on burden shifting that we cited in our brief that refer to when the defendant has a burden to present evidence, and that's if some other witness can testify to what was magically not there. We did not have those witnesses, as the only witnesses that could be there were people charged with offenses for similar allegations. Mr. Focus on Ms. Ayanati. We raised objections to Inspector Troy Cope's testimony and Justine Ayanati's testimony. We raised an issue with the jury instruction, and then there's the issue of the cost of investigation. I set forth all that in case the court has any specific matters it would prefer I address.
What do you think is your best argument?
Twofold. I would say that the initial argument on judgment of acquittal, the statutory construction, the concern with that is if you apply the principal instruction to Florida Statute 106.08 sub 7, in one part it would be extremely redundant. And so that would vitiate adding or reading that.
Section 7 negate the principal theory though?
Well, does it negate it for everything? No, but the legislature specifically, so it's a question of how you read the principal section into another statute. Do you have to read it all into the whole subsection? Or can the court arbitrarily decide, well, it applies to this clause and not the other clause? So does it apply to the individual but not the organizational clause? Because if you apply to the organizational clause, that language is already in that clause, so it would be redundant.
But let me just so I'm clear. I mean, there's a limit as to how much a person individually can contribute. You agree with that?
Yes.
Okay. And your argument, if I understand it, or correct me if I'm wrong, is that the statute here, I mean, what happened here was that Mr. Smith said, basically, your client asked to contribute to this candidate on behalf of your client, which sounds like he's trying to skirt the limits as to what his maximum contribution should be. And if I'm understanding, you're saying that that's not a violation of the plain language or the supremacy of the text, as we like to use nowadays, of the statute.
Well, simply requesting that to make the contribution in his name alone would be insufficient to be a crime. It would have to actually be the contribution recorded and contributed, right?
How is that not indirectly though? Based on what Judge Lambert was discussing, how is that not just taken care of by Section 5? The language indirectly.
Well, Section 5 doesn't address the penalty. And because Section 7 addresses the penalty.
Well, right. Section 7 addresses the penalty, but it refers back to the violation of Section 5.
Absolutely, but.
So how is that not what he did, or at least what he's alleged to have done, being indirectly, stated particularly in the statute itself?
Perhaps what he's accused of doing does indirectly lead to a violation of Section 5. However, he would still have to go through with giving that information to the person who records the information. So if we separate the statute and just look at it indirectly and how does that apply to the principal statute, that's an issue that I would argue.
Well, I guess the question I have is why do we even get to the principle? If the statute says indirectly, if he did it indirectly, why do we even have to talk about the principal language? I think didn't the state kind of charge it as principal or active participant?
Yes, they charge it as that. And
so wouldn't that be indirectly? He's involved, active participant doing this indirectly? Well,
that leads into the pyramiding of inferences, because just our position is just because you ask someone to do something, it still needs to fit for the crime charged. The crime charged was that he made the contribution in another's name. It could be indirectly. And it indirectly addresses maybe he didn't actually make the contribution, but he put the name on the report. But getting back to the pyramiding of inferences, is there's several inferences here. One, that the reason he asked Steve Smith for his name was for the District 9 election or an election in the state of Florida. Two, that he communicated that to Justine Iannotti and Eric Vogelsong. The concern with that is the contents of that communication was not admitted into evidence, so we don't know. We have to assume or imply what was told to them. That Eric Vogelsong filled out the document, and that Eric Vogelsong recorded the document. Now, Ms. Iannotti was permitted to testify that she thought he did it, that he recorded it, or that she said Mr. Vogelsong recorded that document with the Department of Elections. However, We objected to that because there was no foundation for that information, and it was hearsay because she did not see him do that or know that he did that. So that leaves you with 4 inferences,
You're
which
saying there was no direct evidence, though? Is that what you're arguing?
correct.
What about the call from Mr. Paris to Mr. Smith? Is that not direct evidence?
Is that direct evidence?
Anybody comes around, or an investigator of the news comes around, tell them you made the donation and that you thought she would be a good candidate for the county?
So that
I think
may
that's
be-
what the state argues, that's direct evidence. Is that, would you consider that direct evidence?
I think that's direct evidence of aiding and abetting. But it depends how the principal statutes apply to the statute, whether that's direct evidence or not.
Could it be direct evidence of indirect involvement?
Back to indirectly
I'm
again.
chuckling just because that's
I understand.
we're going down a road that's a little complex, which is part of the reason a person reading the statute really wouldn't know what was prescribed by the statute with the addition of the aiding and abetting. So, but to answer your question, would that be direct evidence of indirect participation? Sorry, I'm just thinking it through for a moment. Maybe after the fact. He was not charged as an accessory after the fact. He was charged as a principal or an active participant. And the reason I say that is because with the vague nature of the circumstantial pyramid of inferences that was presented, there's the Mr. Paris could have learned of what Mr. Vogelson allegedly did after the fact and then tried to do something to remedy it, is what his statement to Mr. Smith would account for. After the media got a hold of this, FDLE got a hold of this, Mr. Paris, as you're saying, went to Mr. Smith and said, you know, if someone comes to you, tell them that you made the donation and that you like the candidate. That's direct evidence of doing something after the fact. It's not direct evidence of initiating the crime, directly committing the crime, or participating or being a principal to the offense.
Let me ask, one of your arguments is that you think we should reverse because there was an error in the jury instruction given by the trial judge. The trial judge, I guess, instructed the jury to prove the crime of making one contribution through or in the name of another in any election. The state must prove the following element beyond a reasonable doubt. Richard Benjamin Paris, as a principal or active participant, did knowingly and willfully make one contribution by or through the name of another directly or indirectly in any election. I mean, that's fairly clear, and it seems to come right from the statute, and the judge read that. So how would the deferential abuse of discretion standard that we apply, would that be reversible error?
The concern is the any election language. It's very broad. It does
Was there a
not.
mystery as to what election was being talked about here? She wasn't running for any other seat but the District 9 seat, right?
Well, but our defense is that information that Mr. Paris took that information from Mr. Smith to be used in the District 9 election was not illicit. So it goes to our theory of defense that it had to go for the crime charge. The importance of that is any election could be a national election, could be an election in another state. Now, I do submit that.
But it wasn't. I mean, the state didn't argue that, well, if you don't believe it was here, it could have been anyone in the state of Florida, so, you know, we got them.
Well, just because they didn't argue doesn't mean the jury can't go back there and read the instruction and interpret it as it is, which says any election. So if they're back there for 4 hours like they were, and they're arguing over whether they're deliberating over whether Mr. Paris did this for the District 9 election, or maybe he did it for another election, it doesn't matter.
Of which they heard no evidence that there was any other election in which she was involved in. It has to be an election she's involved in. It's not, well, it's the presidential election, maybe that's what we're talking about.
Well, I think that depends on how we look at the facts, because if we use the representation to Mr. Paris, from Mr. Paris to Mr. Smith after the fact, then yes, that there's an indication that his initial communication could have been about just being I&I. But from the initiation, the initial conversation with Mr. Smith, at least as I recall it, was just, can I use your name in an election? He didn't say which election, he didn't say for which candidate. At least Mr. Smith didn't say that, Mr. Harris told me that. So that would then lead to a potential conviction for any election. That could have been national election, could have been state of Tennessee, it could have been any state. I mean, I will say that there was a definition given that says any election in the state. However, it doesn't say this state, it doesn't say the state of Florida. It just says the state. And Your Honor, I get, like, that's trivial, we're in Florida, I get that. But jurors don't know that this only applies to the state of Florida. They don't know that it's in the state of Florida. That's leading the jury to make a decision whether.
So your concern when you were asking for your special instruction is that the jury might go back and say, this must have something to do with an election in the state of Oregon, so maybe that's what the $200 went to?
Well, my concern is that we're entitled to an instruction that addresses our theory of defense. And our theory of defense was not set forth through the jury instruction because any election was too broad. I mean, the state could have come back and maybe said an election in the state of Florida, maybe that was a middle ground, but there was no middle ground. They wanted any election. And any election is too broad for a Florida court proceeding. It takes it outside the venue of the state of Florida. Just because the acts of riot may have started in Florida does not mean that fits the statute for any election.
There was no juror question during deliberations saying, does this mean any election anywhere in the country, or are we actually talking about what the evidence had to do with it?
Yes, Your Honor, and jurors write questions as they see fit to write them, and
If they're concerned about what their understanding of the instruction.
right, but they don't have to. There's nothing that says to.
You're talking to former trial judges who used to get questions all the time from juries about what does this mean? What does this mean?
And I try cases, Your Honor, and I know jurors have questions, and sometimes it's questions about where can we get lunch, and sometimes it's questions about what time are we going home, and that's the beauty of the American system of justice is none of us should be privy to the communication back in the jury room. So just because they don't bring forth the question doesn't mean they did not deliberate over the issue. I see my time is up.
May it please the court. My name is Richard Palace. I represent the state. Appellants raised multiple errors with trial, sentencing, post-sentencing. The state posits the only error that occurred here was the reduction of costs when the Rule 38B motion was granted, when there was no jurisdiction to grant it because this is not the kind of claim that you can raise in the 38B motion. But
Why is this not a claim you can raise in that type of motion?
I believe this pertains, Your Honor, to the sufficiency of the evidence of whether or not these costs were supported by the affidavit alone. And this court, I believe, is held in Simpson that is based on MAP. This court's opinion in Munaz, I believe, was overruled when MAP held that restitution and the sufficiency of the evidence of that could not be.
I think we held it was impliedly overruled because of.
That's correct, Your Honor. That was impliedly overruled, and then I believe this court ruled along with, I believe, Rivera and Pylon in stating that it was going to go along with that analysis of those two District Court of Appeal opinions. And again, saying MAP impliedly overruled, because I know MAP did not discuss the Munaz opinion.
Notwithstanding that, is the affidavit that was supplied, is that sufficient? I mean, there's no hourly breakdown, correct?
You're correct, Your Honor. All that it states is that what the salary wages were. I mean, I believe it's 4 line items. Whether or not more of that is required, we didn't have a hearing in order to determine any of that information. I mean, had these amounts been objected via contemporaneous objection at the time that the state was putting forth this affidavit and its motion, in order to recoup these investigative costs for FDLE, then of course we would have possibly set this out for a hearing under.
You would agree that at that point, you might have had to bring more, say what his hourly wage was, because this area, $40,000, that's a wage for a deputy or detective in a year.
I mean, as a government attorney, I can attest to that, Your Honor.
So, but you would agree that if you thought it was properly preserved, then you would have maybe had to bring more evidence in of that, correct?
Well, yes, Your Honor. I believe that when you object to the amount in there, we then have to prove via preponderance of the evidence.
So basically, it was incumbent at the hearing when the investigative costs were assessed and you presented the evidence and the affidavit was admitted, I guess, without objection. At that point, somebody, the defense side needed to say, wait a minute, Judge, we object, it's insufficient, we'd like to have an evidentiary hearing so we can flesh this out. And then at that point, the propriety of 42 versus 14 could have been addressed. But now, because there was no objection, it's just a piece of evidence that was admitted without objection. That's the only basis for the judge to award those costs, and therefore you can't. 3800B2 is not a catch-all for things where you had the opportunity to object at the time but didn't.
Yes, Your Honor.
Isn't that what Eisenhower basically wrote in his opinion?
Yes, I believe that is what Judge Eisenhower.
Judge Eisenhower, excuse me.
But
Now, do you disagree? Does the judge have the ability, though, to take that $45,000 and split it into? Does he have the discretion to do that?
I believe costs are reviewed under the abuse of discretion standard, Your Honor. So
He can't just do that. He can't just say. I mean, isn't that what we said in Negron? Some goofball wrote an opinion in Negron that said, "Hey, you can't just if the deputy says it's $23 an hour, you judge can't say it's $38 an hour just because that's how you feel and it's the administrative cost."
well, because I know in Negron.
I was a goofball that wrote that.
Well, if I remember correctly in Negron, Your Honor, we had an affidavit that said this amount, but then it was testified to a completely different amount.
The guy whose affidavit said, that's not what I actually made.
Well, that affidavit looks nice, but that's not what I.
That's not what I made. But and the judge says, well, we'll just fill in the difference here.
Of course, Your Honor, but obviously that's not the situation.
No, I agree.
But if you have the $45,000, does the judge have to issue that jointly and severally liable to each individual, or can he split that? Does he have discretion to split that into thirds?
I mean, that is something that I would need, I think, a more fleshed out record to be able to answer off the top of my head, Your Honor. I mean, like I said, this is abuse of discretion standard. If it was an arbitrary way that he stated it after saying, I've reviewed this affidavit, and, I think that all of this was focused on Mr. Fogelsong or Ms. Iannotti, and then he decides to make, chop the piece of pie into just thirds, then at that point, I might say that was arbitrary. But in this particular case, without me fleshing out the evidentiary record with a contemporaneous objection and then holding the hearing under, I believe, Section 4 of our investigative cost statute, I cannot say whether or not it would have been an abuse of discretion.
So the need for a more complete, fleshed out, to borrow your term, fleshed out record is perhaps why a contemporaneous objection is required.
Yes, Your Honor, that's correct.
In other words, a 3800B motion is not going to be sufficient after the fact.
That is correct, Your Honor. That would not be sufficient. I mean, at this point, I look at it almost through collateral interest, 3850 means. And had you made this objection, things would have been different. You have the hearing, and then you decide whether or not what would be proven in that particular situation. But unless this court has other questions about the propriety of the costs themselves, I'll get into answering at least the facts raised by the defendant. I believe.
Today, you mean what your opponent was arguing this morning.
Yes, Your Honor.
Oh, yeah, go ahead. I hear that.
I mean, just to go in reverse here, we were discussing the jury instruction earlier, and it was raised that there could have been a middle ground of any election in Florida. I believe in order to preserve something like that, that instruction would have had to have been proposed. All that was proposed here was in the D9 election.
Why didn't they just do that? I mean, what's the difference?
Obviously,
What's the difference? I mean, what's the harm to the state? Because that is the election you're talking about, and that is the focus of. I mean, you guys didn't say, well, it could have been an election in Tennessee or Oregon or something like that.
I mean, it's understandable that the only election that was discussed was one to the other, but this is something where we do not have a standard jury instruction for as of this point.
Tracks the language of the information. correct? The District
It's-
9 tracked the language of the information?
That is the language within the information. That is correct, Your Honor. But here, we're just tracking the language of the statute, and I don't believe that saying the District 9 election is an essential element or an indispensable element as covered in at least all the cases that state that when they're rejecting a jury instruction that goes to the theory of defense, it rises to an abuse of discretion. I do
Maybe
not-
the lawyers shouldn't try to outsmart themselves sometimes. I mean, it seems like if that's how you pled in the information, not you, I mean, it doesn't you, but if that's how the state pled in the information, and they want an instruction that tracks the information, and the substance of the instruction is consistent with the statute, I mean, it's still an abuse of discretion. I mean, obviously, I talked with Mr. Bark about why it may or may not have been that significant in the context, but it still is puzzling. Why make it? I mean, it seems like attorneys and judges should think that, there is another step above the trial court level, and are we doing things that may cause big problems that can be readily avoided from an appellate standpoint? Because at the end of the day, if it gets reversed, then it all comes back, and we spend more taxpayer money, and we cause the citizens to come back and have another trial, and all avoidable. We're just using that.
I mean, yes.
I'll get off my soapbox now.
I mean, appreciate it, Your Honor, but I mean, the way that I look at this is, again, we're not dealing with an essential element here. And while obviously, thinking of statements of particulars and the like, when we're actually narrowing down date ranges and the like, that's understandable for wanting to make sure that we're only focusing on what's charged in the information. But I mean, as we said, even if somehow this was an abuse of discretion, it's completely harmless because this is all that was discussed. I
Seems
mean,
like Mr. Barker is saying this statute doesn't apply to what his client was accused and convicted of doing. His reading or his argument to us as to how the statute should be interpreted. So what do you think about that?
under point 1, the first submission, correct, Your Honor?
I don't know which one.
That's-
Whatever you said the first time.
I believe that this goes under, essentially saying whether or not he committed this offense for the JOA. With this judgment of acquittal argument, at the onset, I want to argue that regardless of what we argue with the construction of whether principle it applies to violations of 5A, or if it's outweighed by the mention of some principle or relaxed principle language at the bottom of 7A. In my opinion, we still have the evidence in order for the active participant at a minimum that he acted indirectly in calling Mr. Smith, asking him to use his name, showing the consciousness of guilt by calling Mr. Smith again, Mr. Smith's name appearing on this particular form, and showing that communications were made between the defendant and his co-defendants around both the filing periods and, of course, when reporters were beginning to look into this issue. But that being said, I don't believe we have a stacking of inferences here on that particular argument. I think that this is more of the cases where we say Gustine doesn't apply here. This was pieces of a puzzle being fit together versus asking us to take leaps and bounds off of stacking of the inferences. But that argument being aside, that argument I think being dispositive of not even getting into the principle, I think it's noteworthy that we don't even have the full language of the principle statute quoted at the bottom of 7A when we're discussing officers, agents, anyone who represents the corporate entities of which are focused in subsection 7A. I think the fact that if we look at this as the supremacy of the text, we give this statute a harmonious reading, we read this statute in a way that does not obstruct the statute, and of course, employing the in peri materia factors. I think that I posit we do not have a situation where you're not allowed to charge this person as a principal. I believe this violation of 5A was sufficient to show that. And again, there's still competent substantial evidence to have him as an active participant as well, at a minimum for indirectly. But just to also touch upon, I believe, subsection 3, or I'm sorry, not subsection 3, point 3. We discussed that Ms. Iannotti testified that Mr. Fogelson made that filing. I believe one of the cases discussed where an officer in its lay witness opinion described.
Did she win the election?
She did not, Your Honor.
Oh, what do you guys care about?
This is of course not this is making a contribution in the name of another, Your Honor. We are not, this is not someone being filed for
It's not
wrong.
money well spent then, eh?
That's $200 worth, Your Honor.
Oh.
But, I mean, here, the jury is absolutely able to draw the inference that it was Fogelsong that filed this report. I mean, how many people had access to this? Ms. Iannotti testified, me and Mr. Fogelsong. Did you file it? No. Was it filed? Yes. And we have proof of it being filed, at least by a representative for the Secretary of State. I believe that this is one of those situations where a lay witness laid out a foundation that anyone can look at and say, well, it was Mr. Fogelsong in this situation. And even then, I don't believe that's dispositive of this case. I don't think that that's an inference getting stacked upon another inference in that situation.
Well, Mr. Bark also, in his opening comments, was talking about the state in their closing argument was reciting the Pledge of Allegiance, and is that accurate?
There was a partial citation of the Pledge of Allegiance.
How did that tie into the facts of the case? And that kind of trying to sway the jury to do justice and do the American thing or something?
I mean, I believe after the recitation of the pledge, it was stated that if we didn't have laws like this, we do not have a democratic republic. Obviously, those lines were stated. I mean,
Well, what if the prosecutor was a good singer and broke out into the Star Spangled Banner and started singing that?
well, Your Honor, on this cold record, I would not be able to tell if he sang it correctly, at least in terms of hitting all the notes.
Oh, good point. We can see if they got the words right.
Certainly.
So wouldn't that be problematic? I mean, at some point, that's conveying a message here saying, you know, I'm on the side of America here, and this is an un-American guy on the other side for doing what he did here, and so that's kind of tugging at the heartstrings or the emotions or whatever. However, Mr. Bark probably presented it much more articulate than me, evidently.
Well,
So
yes, Your
why
Honor.
wouldn't that be a problem? At some point, you know, I mean, you have broad discretion in making closing arguments, but it's not unlimited. I think somebody writes that. I don't know.
No, certainly. And again, the Pledge of Allegiance was not objected to below. But regardless,
You got to put them in a catch-22. I'm objecting to the Pledge of Allegiance here. That probably not going to look well to the jury when the defense counsel objects to the Pledge.
I mean, I believe voiced correctly, stated specifically, we would not be showing something against patriotism by giving an objection. I believe I would ask for a curative instruction that counsel's not objecting to the pledge itself. But regardless here, that pledge was not used as, here's the Pledge of Allegiance, you must find this defendant guilty. I mean, the pledge was recited and he spoke of the importance of this law, but in no way was this cited as, if you do not find this man guilty, we don't have a republic. I believe that that's
important. The importance of the argument was about elections, the importance of elections, correct?
campaign finance in the elections, correct, Your Honor. I mean, here we're here for just campaign donations for an election, and here we're talking about the transparency of those. I mean, while of course all of that was discussed, I mean, if I remember correctly, this court held just 2 weeks ago in the Stafford case discussing how I believe it was 2 prosecutors had, reached a fundamental error, and it was because the twisting of the words that they used went into the heart of the state's best evidence, which was Williams Rule evidence, and I believe miscategorized it. So of course you're saying use this Williams Rule evidence in order to find this person guilty. We are not saying use, a clarion call of patriotism to find this person guilty. When he was done making this part of the argument, he went into only discussing the evidence and stated, based on the evidence that we have in this record, I ask that you find him guilty. And of course, the trial court gave him the jury instruction on whatever the lawyers say is not evidence. And we presume that our jurors follow their instructions, Your Honor.
Catch-all saving instruction. Everybody hangs on to like grim death when they're on the field. Right?
I mean, in certain situations, it might be all you have, but I don't believe that's all we have here.
Your Honor.
Here, as I said, this was not something this was all the prosecutor was leaning his hat on. And again, I've looked into cases, nothing's ever said you can't say the Pledge of Allegiance. I mean, I've obviously seen cases where using the Pledge of Allegiance in using biblical imagery like in the 11th Circuit Remind case, that's clearly going too far, especially in the veil of that being a death penalty sentencing.
So we need a Pledge of Allegiance case. I think this is some Judge South here, right?
I mean, if we do have a Pledge of Allegiance case, I believe that this is one where we can say that it did not rise to fundamental error, and even if objected, any error would be harmless in this situation, especially based on the evidence that we have here, which is Mr. Smith stating that the defendant called him twice. Can I use your name in an election? You don't have to pay anything. And then him calling and saying, make sure you say Ms. Iannotti was good for the county. That's a little mischaracterized of the record. I mean that he stated, you say you made this and you made this contribution and you believe that she would be good for the county.
Didn't Mr. Smith testify he didn't even know who she was?
I believe he testified he did not know who she was. He testified that he never made the contribution personally to her. I believe Ms. Iannotti also testified that she never received a contribution from him. I mean, the contributions were only, I believe, received to her from Mr. Fogelsong, Your Honor. But based on the evidence that we have here in the record, even if this was an objected to statement, any error would be harmless, and I do not believe that this error rises to fundamental error, if it was error. But if this court does not have any other questions on the issues here, I'll rely on my briefs. I ask that you affirm the judgment and sentence, but reverse the trial court's order granting the Rule 38B motion and remand for the original cost order to be put in.
Thank you.
Thank you, Your Honors.
Yes, please. I'm glad the closing argument was brought up and the state's assertion that the issue was not preserved. I think it's a lot more complicated than that, because as soon as the state says, why does this matter, trial counsel objects. There's nothing that could be said that would not be an improper opinion as to why this matters. So there's an objection to an improper opinion.
Can't they explain why it matters? Can't the state explain that? You said your defense counsel objected when the prosecutor said, well, why it matters. Can't they talk about why it matters based on the evidence?
They can talk about it based on the evidence, but that's not where it was going. Trial counsel saw that, objects to that, and says improper opinion. Then the state goes on to provide their opinion after the objection is overruled. So that objection is clearly preserved, and there's no limitation for how long that objection goes on for. Then, after immediately objecting to the improper opinion, and the state gives their opinion, we have the Pledge of Allegiance, the recitation of the portion of Pledge of Allegiance, and the assertion that if we don't abide by these laws, we're going to lose our republic, appealing to the emotions, sympathies, sense of civic duty. And so it should be a hybrid analysis, because there's certainly the objection preserved for the improper opinion. There was not an objection for appealing to the jury's sympathies, emotions, sense of civic duty, but that still would be encompassed in providing an improper opinion. And as Your Honor said, at some point the objections become futile. If the defense counsel is jumping up and down, objection, 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 you're going to alienate the jury.
But then we write, so it's not preserved, well, have a nice day. What are you going to do, eh? Catch-22.
Well, and I hope the court would not put us in that position, but that's why I think it's important that it's preserved. They gave an improper opinion after it was objected to, that they should not do that.
Well, speaking about preservation, Mr. Pallas says he'd like his 42 grand back.
Yeah, they didn't object under that it was an improper vehicle to make such a request. Now, it's also important that maybe the word objection wasn't used at the time of sentencing, but trial counsel at the time advised the judge that, Judge, you've got to weigh this, and you can't weigh this based on this affidavit. So the admissibility of the affidavit might be in question, but the court still has to weigh it, and the argument as to what weight, if any, should be given to it was made at the time of sentencing.
So it was admitted into evidence without objection, and the argument was, Judge, you need to weigh it. Based on what would the judge weigh it?
But that's not my issue. It's the judge. You can't decide how much to give because it's not a portion appropriately.
In other words, you believe the affidavit to be insufficient?
Correct. I do. I believe the affidavit itself is insufficient.
So even with that argument presented to the trial court at the time, is this matter allowed to be addressed in a 3800B motion?
No, not the sufficiency of the affidavit pursuant to Judge Eisenhower's opinion. No, it's not. It could be, I'm not aware of any opinions that address whether an Eighth Amendment claim for an unconscionable amount of excessive fine or penalty can be brought through a 3.800 motion, which that also was brought through.
Any cases that apply the Eighth Amendment excessive fines to restitution cases? I know you see forfeiture cases. We've had forfeiture cases in the state.
Yeah.
Civil forfeiture cases, but what about when you have a misdemeanor crime punished by $1,000 and you have $45,000 in cost of investigation? But any cases like that?
Not that I'm aware of. I think
Any
it's a
federal
case,
cases?
not that I have found to date. I believe it's a case of first impression before this court, how the Eighth Amendment should apply to cost of investigation.
Well, I mean, you have somebody sentenced to a year in jail and they get a cost of incarceration assessment of 18 grand or so. And that seems to have passed constitutional muster here. And
Well, this was 60% more than that. So,
I hope it's a felony case, it's 3 years. Right?
Right, but that's part of the thing, is it is a misdemeanor. He did only get 12 months probation. The $40,000 a year of an officer's salary for that investigation, that cost,
Was it all related?
certainly is
to-
excessive in my client's.
Was the 42? I mean, it was the 42 grand all related to the salary, the hourly expense of the
I have no idea. Could have
pretty
been,
vague affidavit? Like
yeah, it could have been the janitor. I don't know.
So you think we should affirm on the cross appeal?
Should affirm on the cross appeal?
You think 14 grand's the number to land on and stay with?
Well, we appealed the 14,000 as well, but we certainly believe we should affirm on cross appeal.
Certainly shouldn't be 42.
Absolutely not. Thank you, it's been my honor.
Okay, thank you.
sir.
Thank you for both sides. Well argued case.
Yeah,